The average Joe might be, listening to a lawyer or listening to us, or trying to engage in some sort of conversation with a legal person, and having difficulty kind of getting their head around some of the terms used. It's almost as though there needs to be a dictionary just for legal terms. And I'm assuming there probably is there? No?
Yeah, there are.
Yeah.
I think lawyers like to write.
I'm sure.
I think lawyers like to make things more complicated than they are.
I'm getting that feeling. Not you, of course, but lawyers in general.
No.
So one of the words that gets thrown around a lot, obviously in your world, is probate. What does probate mean? It sounds like probiotic. It sounds like proactive.
No, it's basically a grant from the court that authorises an executor. It's proving a will, and it's the court. As I said before, wills have to comply with the legislation to be a valid will, and it's the court basically acknowledging that it is a valid will. Obviously, the court only can be guided by an application and an affidavit that's put before it. So, and some probate applications are easier than others. Obviously, if the will's signed properly, it's all done properly, witnessed properly, capacity issues on the death certificate, the names are correct, all of that kind of thing, then getting a grant of probate's a pretty easy, straightforward process. But other times, the will might not be signed properly, so we've got to get an affidavit of the witnesses to deal with it. The person might have clearly had capacity at the time that the will was signed, but they die 2, 3, 4 years later and it says dementia on the death certificate. So the court want to be satisfied that that person had capacity at the time the will was signed, so you might get a doctor's affidavit, those kinds of things. So that's getting more into still non-contentious probate. No one's arguing over it, but it's more complex probate applications.
Gotcha.
So that's what a grant is, and where someone doesn't have a will, dies intestate, like we were saying before, there's no executor appointed. There's a similar grant called a grant of letters of administration, and what that is it's essentially the court saying, well, there's no will, we're satisfied so far that no one can find a will. You've got to answer different questions in your application, like have you looked for it, who are the family members, who's entitled to apply, are there any infants, these are the things that the court are looking for, as opposed to in a probate application, it doesn't need to answer all those questions because it's the deceased testator is nominated, someone will be their executor. So I guess that's the difference between probate and letters of administration. And I could go on for hours and hours, but there's lots of different kinds of letters of administration depending on the circumstances that you're faced with. Like if maybe you've got an executor that goes to probate and dies halfway through administering the estate, there's some special grants for that and stuff like that.
Wow, complex.
In a nutshell, it's probate for a will and letters of administration.
And grants, when do I need a grant? How do I get a grant?
Okay, so the first thing, people ring me all the time. They say, I've been told by the bank I need to get a grant, or I've been told by Landgate or whoever it is, and they're really stressed out. And how do I get a grant? All this, and I start calming them down and just go, hang on, hold on a second. The first thing we want to do is figure out if you even need a grant, because there's a lot of misinformation out there. You get some punter that works at the bank telling them, you need a grant, to get the money out, when that might not be the case. It might say you might need a grant, but no one's read it properly. Right. So typically, if under the banking regulations, if a person's got more than $50,000 worth of assets combined across a number of accounts with one financial institution, the bank will almost certainly require you to obtain a grant of either probate or letters of administration from the Supreme Court. The second situation is with interest in land. So if a person owns land as a joint tenancy, where they're jointly co-owners of the property, it may be very well be the case that you just transfer it straight across into the survivor's name, and you don't need a grant. We use a death certificate to close the account, to transfer it over at Landgate. But if someone has an interest in land in their sole name, usually we get into this situation with probate with like married couples where the second spouse has died, so like grandma's died and then granddad has died, because they've already done that survivorship of all the bank accounts and houses and stuff. So that's normally when, so I always try and see if I can get out of getting a grant, because it's expensive, it's time consuming, you've got to do affidavits, you've got to do a schedule of assets and liabilities. There's actually an application before the court. You can do online probate application stuff. They've got like a probate wizard on the Supreme Court website, but for letters of administration you can't, because as I was saying before, if there are kids involved or third party family members involved, you need to seek their consents. You might need to do up a deed that gets lodged with it. So that's more complicated. So usually people don't do those applications themselves.
Okay. So on that note, are there any issues that I need to look out for if I'm applying for probate? Is there something that I need to?
If the death certificate states that the deceased died of dementia or cognitive impairment or something to do with capacity, you're almost certainly going to get a requisition from the court saying, well, can you please explain that as at the date of signing the will that they had enough capacity to sign it.
Okay.
If it's not witnessed properly, the inks are inconsistent, it might be that a page is missing and someone's not witnessed the document. The non-contentious probate will say that when you do your affidavit, you actually have to sign the front somewhere on the will. You sign it and you get your witness to sign it, and a lot of people forget to do that and they get a requisition from that.
What if I can't find the will? Where might I look? What would I?
Well, you have to. Well, okay, so there's a couple of things here. If you can't find the will, and you've absolutely looked everywhere, then it is likely that you will need to make an application for letters of administration, because there will be a presumption that the will, if you can't find the original, it's a presumption that's been destroyed by the will maker. So one course of action or one direction is to get letters of administration. In some circumstances, it is possible to get probate of a photocopy of a will or a reproduction of a will, but you have to convince the court that the deceased did not rebut the presumption that the deceased did not destroy the document with the intention of revoking it. So, for example, this never happens on the evidence, but the will was done in the 1st of January 2022. We're at the moment where we're at the 31st of January 2022. It was signed at my office. It was all done. They said that's what they wanted, and between, they die in February or something like that. It's only been a couple of months since they signed the will, and yet the original's gone missing. There might be conversations that the deceased has had. I've had one before where someone put a photocopy of a will in an envelope, thought it was their original will, can't find the original anywhere, but they handed, after it was signed, they handed the envelope to their mum or dad and said, "Mum, if anything happens to me, my will was in this envelope," and it went in the filing cabinet and that kind of thing. And it was very clear that, it might be an oversimplification, but it was clear that they intended for that document to still be binding, even though no one could find the original.
Wow.
So there is a way of doing that if you can't find the original, but I mean, some places to look in answer to one of your questions is always the Office of the Public Trustee, if you can find out if the person had a former solicitor acting for them, maybe a family lawyer, bank security deposit box is a good place to look. If I usually do a conveyancing search, like a Landgate search, to see if they did a power of attorney or who did their conveyancing with the land, because if there's a power of attorney registered, then you can find the lawyer. You might be able to find the lawyer, and then you can track it that way. But it's difficult to find it if it's
Yeah.
been misplaced.
And what if it's damaged? If there's, you know, say, I don't know, staples in it, or, you know, punch holes or something? What?
Well, it's the same as before. As if staple holes can raise a presumption that there was something attached to it. And so you've got to satisfy the court that there wasn't a codicil or other document attached to it. All those kinds of things. I've had wills before where they've only been witnessed by one witness instead of two witnesses.
Yeah.
So the court they've got a dispensing power to say, well, it doesn't quite meet the legislation as long as there's enough evidence there. And not only that, they usually require you to ask anyone that's going to miss out or is prejudiced by your application to consent to.
Yeah.
You know, so what you would do is say, well, if this will is proved, it only goes to my oldest son. And if it's not proved, it goes to my son and my daughter and my other daughter.
Yeah.
The other two kids might turn around and say, well, you know, look, clearly the evidence shows that it was meant to be binding, even though it was witnessed by one person. It's my dad's signature.
Sure.
And you can go through that process as well.
Yeah.
So,
Yeah. Okay.
I mean, doing a will properly avoids all of this stuff. But it
Obviously,
happens.
sort of going back to what we were talking about before.
And you know, at the end of the day, if everyone agrees, you can go by consent. Usually, it's where they don't agree that it becomes a problem.
Massive.